Daniel, you lent Georgia your car. Now, for the purposes of these proceedings, I'm going to treat this as your car. The reason I put it in that way is because although your dad had what I'm going to call paper ownership of the vehicle, in law, you had exclusive possession of it. You relied upon it, it had a value, it was your thing. And although he hadn't handed over the relevant documents, you were entitled, as a matter of law, to treat it as yours. You lent that car to your sister, knowing, bearing in mind what you've told me, that she's a little bit irresponsible, and she had an accident. It wasn't a wicked accident. It was an accident which she could have died in. That's what new drivers do from time to time, very tragically. It wasn't egregious or the worst I've ever seen by any stretch of the imagination. But the reality is, because she must have known, or it would have been generally known, that she had third-party insurance only, she is, because it's her responsibility, her negligence in law, liable to put you into a position you would have been in but for her negligence. That's the legal position. She can only be liable, it seems to me, to replace what she knew she was risking in the first place. In other words, she can't be liable to buy you a very expensive new car. What if you'd got a Porsche or something of that kind? The risk that she took when she took that car out was the value of the vehicle, which is somewhere between £1,130 and £1,210. I deem the value of the car she took out to be £1,170, not the £3,000 you're claiming for a new car. Just because she acted negligently doesn't give you the right to get whatever car you want. She has to know when she takes out a thing how much it's going to cost to repair if she does something bad with it. It's like anything else. In the circumstances, therefore, in respect of the value of the ar, this court will award you £1,170. I cannot give you any award for the insurance. You're claiming £506.93. That's for the insurance on an entirely new vehicle. It may be that your premium went up. It may be your premium would have gone up in any event, I don't know, because you have no evidence about that. It may be it wouldn't have been massively significant on the same car, of the same value and the same mileage. That's not the quote that you gave me. In those circumstances, I have to dismiss your claim for £506.93. Your claim succeeds to a limited extent of £1,170. Now, what that money won't do is repair a relationship which was very, very good. The two of you weren't just close, you've got so much in common. And boy, is that worth more than £1,170. Agreed? I can't force you to do this, but it's a starting point today. Before you leave court, would you be prepared to shake hands? Would you?
Yes.
Thank you. Please. That's the award of this court. I wish you the best of luck.
Thank you.
Daniel was awarded £1,170 of his original claim. Let's find out how both parties felt about their day in court.
It could have went better, but it definitely could have went worse. I feel that now it's definitely time just to put all this behind us and try and get a relationship back with my sister.
I'm still quite hurt that he even brought me in the first place. All of this just over a wee bit of money for a car. It's like I was in an accident where I could have been seriously injured and all you care about is money, like, it's ridiculous.
It's
ridiculous.
It's not to do with the money, George, it's to show show some responsibility. She's been irresponsible and she's not taken any responsibility for it. It's all down to her. Eventually
We can get back, but at the moment I'm just still so mad at you.
Fair enough.
For more Judge Rinder cases, click here. And if you've got a legal issue yourself, get in touch with us by clicking over here.